Welcome to this explainer. We're diving right into a massive, high-stakes legal stress test, how South Africa's 1996 amended text was essentially put on trial to finalize a nation's democracy. It's an absolutely incredible moment in legal history where an entire constitution was heavily scrutinized to see if it could truly deliver on its foundational promises. To grasp exactly where we are in history, just think about the timeline. Back in May of '96, the Constitutional Assembly adopted a new constitutional text. But by September, the Constitutional Court actually withheld certification because they found several major flaws. This meant the Assembly had to completely rework the text, fixing those specific shortcomings in just a matter of weeks, and then submit an amended text in October for a final, incredibly rigorous evaluation in November. Which brings us to a really fascinating premise. What happens when a country's new constitution must pass a strict legal rubric before it can even become law? Like, how do you actually grade an entire constitution to ensure it holds up? You can't just wave it through. It has to be rigorously tested.
Well, the answer is this rubric of constitutional principles. These were a prescribed, completely unyielding set of democratic rules that had been negotiated beforehand. The Constitutional Court used these principles to impartially evaluate every single clause of the new text. It wasn't about whether the judges personally liked the laws, but whether the laws strictly complied with these pre-agreed constitutional principles.
Okay, let's dive right into Section 1, Defending the Bill of Rights, Liberties, Trade, and Emergencies. Now, you might assume every single constitutional right applies to absolutely everyone, right? Well, the court had to neutrally examine exactly who gets what rights. An objection was raised that the right to freely choose a trade, occupation, or profession was only given to citizens, not everyone. So the court had to look at whether limiting this right violated international norms. Ultimately, they found that it didn't. They noted that exemplary democracies, places like India, Germany, and the US, do exactly the same thing. They reserve the right of occupational choice specifically for citizens, while other rights, like freedom of association, remain totally universal. This next part brilliantly illustrates how the amended text expanded protections during a state of emergency. You see, the initial draft was heavily criticized for arbitrarily leaving certain rights vulnerable during an emergency. So the Constitutional Assembly went in and explicitly listed these non-derogatable rights. That means rights that can literally never, ever be suspended, even if the country is facing an absolute crisis. They expanded the list to include things like protections for children under 15 in armed conflict, and the exclusion of illegally obtained evidence if it would make a trial unfair. Moving right along to Section 2, Rules for Changing Rules, Protecting the Constitution. There's a really clear contrast to point out here. Passing an everyday, run-of-the-mill law, that just takes a simple majority of votes cast. But changing the Constitution itself, that's a whole different ballgame. That requires a 2/3 majority in the National Assembly. The constitutional principles demanded these special majorities to ensure the foundational laws of the country are totally insulated from the short-term political agendas of ordinary majorities. But, it's not just about getting the votes. The process itself is absolutely crucial. The court noted the strict procedural steps required for any amendments. You have to publish the bill in the National Gazette 30 days prior just to allow for public comment. Then, you must submit it to provincial legislatures, actually debate it in the National Council of Provinces, and wait another 30 days before the National Assembly can even cast a vote. This essentially forces transparency and prevents any government from just rushing through massive constitutional changes in the dead of night. Here is the really crucial point. Even a massive 2/3 majority in the National Assembly isn't enough to change the Bill of Rights. Because of a previous failing found by the court, the amended text introduced a brand new entrenchment mechanism. To change the Bill of Rights, you absolutely need the backing of 6 out of the 9 provinces in the National Council of Provinces. This makes the Bill of Rights exceptionally secure from the whims of whatever political party just happens to be in power at the time. Let's jump to Section 3, Balancing State and Local Power, Decentralization and Frameworks. The initial constitutional text actually failed certification precisely because it didn't adequately define local government structures. It was too vague. The amended text passed the test by establishing a very clear framework of 3 distinct municipal categories: self-standing municipalities, those forming part of a larger comprehensive coordinating structure, and finally, those performing coordinating functions, like regional councils. This provided the necessary architectural design for local governance that the original draft completely lacked. But think about this. What happens if a province just completely drops the ball on its executive duties? Can the national government just swoop in and take over?
Well, the amended text carefully outlines the exact multi-step process the national government must take before it can legally intervene. They have to first issue a directive explaining the failure. If they absolutely must intervene to maintain essential standards, they have to notify the National Council of Provinces within 14 days, and then the council must approve it within 30 days. It is a perfect balancing act between national security and provincial autonomy.
And while we're on the subject of provincial autonomy, the court also had to verify that the rights of traditional monarchs at the provincial level were adequately recognized. Crucially, the amended text ensures that if a province writes provisions for a traditional monarch into its provincial constitution, those provisions are structurally protected from arbitrary national interference. Simply put, the national government can't just step in and override a traditional monarch's status.
All right, Section 4, guarding the watchdogs, independence and impartiality.
So you really have to ask yourself, who ensures the government actually follows its own rules without fear of political retaliation? The watchdogs. We're talking about the public protector and the Auditor-General. They investigate sensitive government affairs and track public funds. But if they uncover corruption, the politicians they expose might suddenly decide it's time for some unexpected restructuring, right? So how does the Constitution actually protect them?
Well, the answer lies in rigorous firing protections. In the first draft, the court essentially said, nope, their independence isn't safe enough. So the amended text massively ramped up the protection. Now, to remove the public protector or the Auditor-General, you need a staggering 2/3 majority vote in the National Assembly. This virtually guarantees they can't be easily dismissed just for doing their jobs and holding the ruling party accountable. Now, the Public Service Commission, which promotes public service ethics, was treated slightly differently, but the solution is equally clever. Its independence was structurally secured by distributing power across 14 different commissioners. And here's the genius part. They are appointed by 10 different legislatures, 5 by the National Assembly and 9 nominated by the provincial premiers. It's like a giant puzzle. This broad distribution makes it incredibly difficult for any single political entity to unfairly dismiss or control the commission. And that brings us to our final part. Section 5, Final Constitutional Certification, Passing the Test. Impartially reviewing all these revisions, the court acknowledged that the Constitutional Assembly actually did it. They successfully fixed the flaws from the earlier draft. The court noted that the Assembly conscientiously addressed every single shortcoming identified just months prior. The amended text was a massive structural upgrade across the board, tightening up the frameworks for local government, securing the watchdogs, and deeply entrenching the Bill of Rights. Throughout this whole process, the court made sure to explicitly remind everyone that its role was strictly judicial. As they stated, grading against the constitutional rubric was their one and only job. It was a legal exercise, period. They were not there to judge the political wisdom of the laws themselves, but simply to measure the text against the unyielding constitutional principles they all agreed upon to birth the new democracy. Which leaves us with a final, provocative thought to chew on. We've seen how meticulously this text was tested and refined to protect human rights, balance power, and guard those crucial watchdogs. But as democracies naturally evolve and face unforeseen challenges, will the strict checks, balances, and independent watchdogs certified in this text be strong enough to withstand the unpredictable future of a young democracy? It's a question every citizen must continually ask. Thanks for joining me for this explainer. Keep learning and keep asking the big questions.